Good evening, friends and fellow travelers. We have with us today Nitya Ramakrishnan, Senior Rights Advocate, Supreme Court. We have with us Mihir Desai, Senior Rights Advocate, Bombay High Court and Supreme Court. And we have Henri Tiphagne, Rights Advocate, I think all over the country. Thank you so much, all of you, for being with us. We are discussing today the Supreme Court of India again, maybe for the umpteenth time, turning its gaze on custodial torture. Custodial torture is something which has actually shamed and dogged our entire democratic setup for decades now. I still remember the famous Khatri judgment, which we quote so often, is actually the Bhagalpur blindings case, which is the Khatri judgment, but it's known as the Khatri judgment. How do you see the kind of steps taken in this last order of the Supreme Court delivered yesterday, where we have monitoring committees, state level and district level? Does it go far enough? How do we ensure that the state gets accountable? Nitya.
I think it does go far, in as much as for the first time there are committees to monitor this turning of the gaze into the custodial situation. And it is also a positive development that members of the committee are not only bureaucrats. The district committee has an elected representative as a member, either the mayor or the panchayat head, and the state committee has somebody from the Women's Commission. And the district committee has been charged with the obligation of reviewing footage to ensure cases which are not otherwise reported are reported. It's a positive obligation cast on them. So I consider this an important, very important development. But yes, I think we can go farther also. I feel that, multiple centers viewing footage real time is important, both to ensure that there is no editing of the footage or manipulation of any other kind. We had suggested, aside from this, we had suggested that there should be a 24-hour real-time viewing possible from a room in the magistrate's office. It has long been my view that the magistracy is the single most important unit in countering custodial torture, because that is the court which has the first and closest access during police custody and even during judicial custody. So the possibility that a magistrate may anytime tune into a police station within that jurisdiction and see what is happening.
There is an observation, Mihir, Mr. Desai, there's been an observation in this order, which was delivered in the Paramveer Singh Saini versus Baljit Singh and others case. There's an observation that after the earlier case of 2018, the Ministry of Home Affairs did not go far enough, did not actually put all the compliance issues that were required in that order before the court. There's a clear observation in this judgment that was delivered yesterday. So, I mean, we are back again. D.K. Basu in 86, which went out, orders passed right up to 2015. We've had 36 cases looking at sovereign immunity, custodial torture, many of these issues. But how do you eventually get the executive and the legislative and administrative bodies and law agencies to comply with these directions? I mean, I remember in this order as well, there is a requirement that there'll be a big poster-like board outside the police station informing people that there are CCTV cameras everywhere. Basu also said that there should be a notice outside the police station saying FIRs should be available for the accused in the language of his or her understanding, not necessarily language of that state or that region. But compliance, I mean, how do you get compliance? How do you ensure compliance?
Let me start by saying that according to me also, I totally agree with Nitya that this is an extremely important judgment. On custodial deaths, of course, custodial death has always been a crime. It's not that it has never been a crime. Custodial torture has always been a crime. Nobody gets prosecuted and nobody gets convicted is a different matter, but it has been, any kind of assault is a crime. So that's not an issue. But if you see, like in the 80s, Okay, when the custodial deaths became very, very important, the court started by converting the tort regime into public law compensation regime by giving people compensation, victims of torture, victims of custodial death, etc., etc. Their heirs, etc. Compensation, but prosecution, namely prosecuting the police who are responsible for it, and it becomes very difficult at times, because while you know that a particular person has died in police custody, you don't really know which police officer actually battered, actually killed that person. That becomes a very difficult thing. So this particular judgment, okay, will take us much ahead in that direction of enabling successful prosecutions of not only deaths but also torture. And just one more thing I wanted to say, that you're right, that implementing this order is a difficult task at two levels. If you see Prakash Singh's judgment, I mean, of course, I have my own reservations about many of the things of Prakash Singh's judgment, but even that judgment has yet not been implemented. And there are people who are trying to fight for implementing that judgment. So I think while the Supreme Court has done its job, now it's also the job of the civil society to get itself activated, okay, and ensure it can be one of the major planks of the next few years to get those who are working on police reforms, or those who are working on police accountability and transparency, to ensure implementation of this judgment in different parts of the country. I think that is something which is very important. We need to look forward to that.
Henry, you of course it was on behalf of you and evidence that Nitya intervened in the Supreme Court, but you've been yourself very, very active on the whole issue of torture. I still remember you had a couple of public hearings with Justice Horsbit Suresh years ago, and the whole question of torture, on the fact that India should ratify CAT. I mean, many of these campaigns, national and international, you've been intrinsic part of. The recent horrendous cases of father and son a few months back being killed in the Tamil Nadu police station. You've been active on that. How do you see this judgment and the other one that was also passed, I think, yesterday by the Madurai court?
Well, Teesta, I mean, I would join both of them in saying this is a very good beginning, very important beginning, and I second Mihir in what he said now. What is most important is that civil society groups take this judgment and take it to the streets. Now, for example, we have our joint action against custodial torture that was formed immediately after Satangulam, with about 15 political parties and over 80 organizations which are on a platform. Mr. Thiagu leads it, convenes it. It's important that all our member organizations have this judgment in Tamil with them, so that when a custodial violence takes place, they're able to be there, showing the judicial magistrate what his duty is, showing the dean of the medical college where the body is, what has to be done, etc., etc. And in matters like where we talk about CCTV cameras, I want to recall that in the Satangulam magistrate's report, the entire narration of how the video was completely written off was mentioned in writing in the 176(1)A process.
So that report is a very good report as well. That report is a very good report.
So we need to take both these judgments which you are referring to people. And it is people, by using these judgments at the appropriate time in their own creative ways, that will further work. One thing that I wanted to add in terms of the CCTV camera is now the opening that has been created. I know we also attempted to try to bring the legal aid inside it, the Legal Services Authority inside. But even now it is possible for us to move the District Legal Services Authority and the Taluk Legal Services Authority to ensure that they take this judgment further on. And if there's some creative member secretary or a chairperson of the SLAC who works in Tamil Nadu, or a DLAC who is a little creative, we will be able to see that move forward. So I think it is up to us. There might be a few things we would have wanted which are not there, but I think it's up to us to take it forward. Now, in terms of the judgment in the Madurai bench, what we got was, for the first time, Teesta, our fight was always at the postmortem area, where the family was never allowed inside. You had a whole posse of policemen. All our people, families, human rights activists are thrown out by the police, and everything happens that way. Now we have a right to be there. We have a right to, the postmortem cannot start without the kith and kin seeing the body. Allowed to take photographs, get copy of the postmortem certificate, get copy of the video. I think this matters. And this will move this entire jurisprudence of custodial violence further.
So what we are all saying, or everybody is saying here, is that apart from the fact that there's been some few steps forward, significant steps forward by the Supreme Court and Madurai bench of the High Court, of the Madras High Court, we also need to now make sure this gets implemented. Local language translations, interacting with other statutory, semi-statutory bodies to make sure that this gets implemented. Nitya, I want to come back to what you've said very, very importantly, which I believe not enough people know about. 176.3, the court of the magistrate being the first court that needs to be empowered. And it takes me back to those days post-Gujarat 2002, the Tamang report, the report,
Yes,
the Ishrat
yes,
Jaha case. Yeah, you know, I was thinking that, and yet you have another magistrate's report in the Tamil Nadu case that Henri mentioned. You know, excellent work done by the magistrates level. And we have a very top-heavy way of looking at the judiciary when we don't appreciate actually the law that is being set at the magistracy level, you know. So would you just explain a little bit more the significance in your experience of this CRPC provision and what it means?
Magistrate's role is not only under 176(1)(a), Teesta. Magistrate's role is person arrested has to be produced before a magistrate. Why? Why can't he just be in police custody? The reason behind that is any ill treatment, and the DK Basu guidelines now brought into the CRPC 48 hours, and this is Arnesh Kumar judgment saying it is the duty of the magistrate when an accused is brought for further remand before the magistrate to explain all the constitutional rights to that accused.
Yeah.
So aside from post-violence, 176(1)(a) comes post-violence. I'm saying even at the stage of arrest, first 24 hours up to 24 hours, actually it's not 24 hours. It's at the outer limit 24 hours, but as soon as may be, they have to be produced before a magistrate, which people forget. They think 24 hours they have, but it's whatever reason. After the first arrest, when produced before the magistrate must engage with the accused, with the détenu, to ask about treatment, about ill treatment, explain custodial rights, explain constitutional rights. So that is the most important thing. And often our magistrates are so overworked. It's not that they don't wish to do it. They're so overworked. I've been suggesting to law schools for years, don't send your interns to us. Don't send your interns to the Supreme Court and the High Court. Do also that. But send them to the magistrates.
Yeah.
That will set in motion a dynamic, which, you know, we can't even imagine. Will have a snowballing effect. Good effect. That's one thing. Now I would suggest they should send interns to these district and state committees set up by the Supreme Court. So ensure that they work to engage with them to make them a reality. So the magistrate at that level is important. It is that magistrate to whom the accused must feel emboldened to complain about any ill treatment. A third situation, not in all cases, but sometimes that arises is when an accused is brought to record a confession, so to speak. There is a very, very important safeguard in the CRPC that if the accused says that he does not wish to make a confession, the magistrate shall not order further police custody. So that's yet another situation where the magistrate has an interaction with an accused and where the accused should be able to feel free to tell the magistrate, look, this is the nature of pressure that's been put on me. Of course, people tell us that they did try to convey this to the magistrate, but often the magistrate just puts a rubber stamp on the confession and sends it. But in order to stop that also, civil society must engage with magistrates' courts, which they simply don't do. They're so hoity-toity, want to go into fancy offices. And this is the situation in Delhi and Bombay. Can you imagine what must be the state of a magistrate's court in a Mufassil town? Or a small, a cluster of villages which are covered by one magistrate's court. So to engage, to enthuse that magistrate, to, infuse energy into that, because that is the first brush of the judiciary with the criminal justice system. So first, when brought for further remands, for custodies, for police extension of remand, extension of police remand, judicial remand, whether DK Basu guidelines of every 48 hours producing them before the doctor has been complied with, whether they've been told the grounds of arrest as required under the Constitution. All this when the magistrate does. If such a magistrate is also empowered directly to see what's happening inside the police station.
That will be very powerful, extremely powerful.
Yeah. So these three things, 176, 1A, which is after, initially it used to be just any death in police custody. It was in 2005, I think, that this was 176, 1A was added in the Indian CRPC to say first that it should be a judicial magistrate, and it's any custodial violence. Magistrate, hospital, if it is on the orders of a magistrate or if it is in custody, then any violence has to be mandatory inquiry. And that's how the Tamang report came, and that's how the report referred to by Henri has come. And then the victims have a right to be heard in that process. That's also there in the CRPC as it stands today.
Yeah.
So this, if we are able to activate, I tell you, it's better than 1 million writs, frankly. Because also a self-generating mechanism is important, because it may not even occur. आप लिख दीजिए police station के बाहर कितने लोग हैं जिनको ले जाते हैं जो अनपढ़ हैं. And even if they see the words of the Constitution written on the walls of the police station, and while they're getting thrashed, where is the access to justice? They may know their rights, so therefore they must be outside the police station. An agency which is a self-executing process against custodial torture, which is not reliant only on the victim or the victim's family or anybody on the victim's behalf raising a complaint. And that and what we asked for is not something so unusual. Already the Supreme Court has said a visitors committee, non-official visitors committee, which has the power to conduct random checks on prisons and police lockups. So if the Supreme Court, they can be given power to conduct random checks, why should not an outside agency be given access to this footage, real-time access to the footage? Instead of going to the police station, they can see. So that, I think, somehow we must get the magistracy. Okay, maybe today we don't have that nature of access, but I think it is quite a bit that a committee with an elected representative or a member of the Women's Commission is there. It's now our business to activate these committees, to ensure the monthly reports are given, to every month, every 15 days, or to ask them every week even to review what is happening inside the Thana and say, "Arey, yahan pe galti ho gayi hai," we will ourselves. We had also asked for a dedicated complaints mechanism. Henri had said that there are already some police complaint authorities which should be dedicated to complaints of torture. So as soon as there's some suggestion that there is torture, then the victim should be removed to a hospital away from the police station. Complaints must be registered, etc. So this should be self-generating instead of having victims run from pillar to post, run to lawyers, be at the mercy of lawyers before complaints are lodged of police torture. So one way of ensuring this implementation is to ensure that at least some part of this gets automatically triggered.
Mihir, you were also amicus in a case in the Bombay High Court not so long ago when something similar was being looked at. Am I right?
Yeah, in fact, yes, that is true. In fact, that case is still going on and comes up from time to time.
Mm-hmm.
It started with complaints which some people had made through a letter to the Chief Justice about custodial deaths, because Maharashtra, as most of you know, has the highest rate of custodial deaths in the country. So and of course, hardly any convictions, etc. But there are two things which I just wanted to talk about as far as the order of the Supreme Court goes. One is that, many times you have Supreme Court or High Courts issuing directions, good intention directions, whether they pertain to, how CBI should conduct itself.
The livelihoods of the people, which provide the security, the food sovereignty to this country.
What is happening?
Sorry, I think somebody's...
We are impacted.
Henri, has somebody unmuted themselves?
Not here.
The ruling party, the
What is happening?
government is that farmers' protest is creating inconvenience in Delhi.
What has happened?
Essentials are now not
Somewhere.
able to come in, and so on, etc.
We can't make out what has happened. You want to?
Even in the past, to
Is
actually,
a video playing on one of your phones or something? Can you check?
we have come together to show that no, this
Huh?
is our
Or
cause.
one of your devices?
Number one. Number two,
By mistake, is it playing?
the developments in the last
Not our
few
thing, no?
No. Now it's stopped.
Yeah. Okay. Anyway. Yeah.
Okay.
Sorry. Yeah. Yeah.
No, so just coming back to it, that since last 40, 50 years, you have had Supreme Courts and High Courts issuing possibly good intentioned directions, but without really trying to find out whether they will work or not work, and without trying to look at whether whether a mechanism is put in those directions to make them work. Here, I think the Supreme Court has thought much deeper into the issue.
Deeper. Yes, that's true.
And there are two things which immediately come to my mind. One is they not only talk about the video link and all that kind of thing and camera, CCTV camera, but they go into depth as to the defective cameras. Okay, as to if the cameras, I mean, it's not just giving a direction.
Great attention to detail.
Yeah, they've paid that attention to detail about if they, because this is what we have faced here, that whenever there is a problem, okay, but even there are some police stations which have CCTV cameras, etc. They say that the camera was not working at that time, and the matter ends there, and the whole thing is then closed down. So they have paid attention to that. That's very important. The second thing which I think is very important is they have not talked only about police. They've talked about police.
Yes.
I was going to come on to that. They were talking about six agencies.
They've
Six
talked
agencies.
not only about 6 agencies, but remember they have said about any other agency which is the authority to arrest, which would include the army in Kashmir. Please understand that, or the army in Northeast. Okay, so I mean this is something which I'm sure. I'm sure can be used not only vis-a-vis these 6 agencies, 7 agencies, but also in respect of other territories like Kashmir or Northeast, where there are allegations of torture, where there are allegations of custodial deaths, etc., etc. So, I mean, in that sense, it's because they say that it will not only apply to these agencies, but also any agency which has power to arrest and interrogate. So, from that point of view, also, I think the Supreme Court has really applied its mind very, very carefully, okay, to the details, and that is, I think, important. Now, just one last thing that here again in Bombay, when we were arguing that case, I was there. Even our common friend Dr. Yuk Chaudhary was also part of the case. So when we were handling that case, the court had initially ordered that CCTV cameras should be everywhere, And but then later on they said, okay, do a pilot project for 25 police stations. So it was whittling down, and always the state throws up the money part, that we don't have the money, we don't have the technology, etc., etc. Supreme Court has disregarded all that. Supreme Court says that yes, you'll require money, you better pay up the money, and that is part of the order. And also, what is important is Supreme Court has kept the matter. It is using the power of continuing mandamus. Ask them to file reports within
6 weeks.
And I think that is where I'm sure Nitya and all will have, additional can make additional pleas and additional directions can be issued. So it's an excellent order, but it's a beginning, and let's see how it progresses.
What we are discussing today is the order passed by Justice Nariman, Justice Joseph, and Justice Anirudh Bose of the Supreme Court. And what Henry was talking about is the judgment passed by Justice G.R. Swaminathan of the Madurai bench of the Madras High Court. And I think it's also very important that we keep remembering that there have been over 3 dozen, I was just trying to read up, over 3 dozen plus judgments periodically on the issue of custodial torture in our country. And of course, the longest possible writ of continuing mandamus was the D.K. Basu, which began in 1986, December 18th, first very significant order, and the last order was 2015. And therefore, I mean, it's good that the human rights jurisprudence gets deepened this way. But we have miles to go. Henry, this order, which you were good enough to pass on to me today, the Madurai bench order, very importantly talks about the whole process of the post-mortem. You referred to this in your earlier remarks. And I mean, you look at any sort of crime, whether it is custodial crime, individual crime, you look at an accident, or you look at targeted crimes against Dalits, against minorities, whatever. This medico-legal procedure has been abused. There's no watchdog on it. There's no spotlight on it. In fact, I once was talking to some friends from the Physician for Human Rights, and they've been refused a visa for like 2.5 decades to come to India because they simply wanted to come and review some of these procedures, which are basic procedures. So, I mean, what does it mean when India, 70 years plus down, is not able to fine-tune these processes with transparency and accountability? Processes like the postmortem, which have got to do with freedom, which have got to do with life, which have got to do with dignity.
Now, it's quite factually, Satangulam took place where the father and son were killed in custody on the 19th of June night.
Yeah.
And on the 20th, and then there were 4 other cases, one of which we got the judgment, but there was recently where on the 28th of October he was taken into illegal detention, kept outside the police station in a hotel for 2 days. So no CCTV cameras operate there. That CCTV camera has been removed. Then once again, the same process of bringing him to the police station, taking him before a doctor, same Satangulam style, judicial magistrate remanding him, etc., etc. He dies in judicial custody in a sub-jail. Now, in all these cases, the problems start with the doctors, because very rarely you have post-mortem being handled by professors of forensic medicine and who are above board, and there are not too many today. And therefore, when it comes to a lower level, the executive also enjoys sending it to a lower level. In this particular case where we got the judgment, it was done in Usurampatti, which is located 45 minutes from Madurai and 30 minutes from the next medical college hospital on the other side. So 30 minutes this way and 45 minutes this way, you could have come to a medical college hospital where you would have had forensic experts. So 2 doctors who are not forensic experts did this, and the video clippings were 7 minutes. 7 minutes taken on a mobile phone. Now, all this is being shattered by this judgment. And what is most appreciable here is that the judge was not only interested in ensuring that we get CBCID to investigate this case, but also in particular that he said, okay, there is a public interest and I am willing to do this as a public interest matter, provided you draft and pass it on to me, and I'll also pass it on to the state. So the counsel for the government also saw these standards before it was passed. So it was not we intervening with the court. The court sort of engaged the state in the process, and I think that is the victory. And I think henceforth, there is material now to work with forensic experts to see, please keep yourself away from these kind of policemen. That I think is the victory that we get in the process.
I think we should also spend a few minutes, because in a fascinating discussion, a few minutes in terms of our, not necessarily concluding, but a couple of a few remarks on the culture of torture. I mean, I think the whole culture of torture that we have in our country, in South Asia, in the world, I mean, I'm not trying to say that it's only uniquely our own, but, and relate that to the fact that the reluctance of several governments to actually ratify CAT, to ratify the Convention Against Torture. And what does that mean? What does that mean when India stays away from this international human rights regime? We want to be the most economically the most powerful. We want to have the most powerful. But on the question of human rights, we do not want to measure up to certain international standards. What does that mean, Nitya?
See, I think culture and impunity, it's not somewhere. Well, 2 things I would say. One is somewhere we as a people, through our movies, through our conversations, through our middle class, upper middle class interventions, actually believe that torture is indispensable to law enforcement. We are able to live with this duplicity, believing that all right, it's necessary, these idiots, either human rights activists or others, well, it's necessary to pay lip service, but really, maybe many of our judges believe that you cannot arrive at the truth, with table manners, as somebody once said to me. So that is something we'll have to tackle outside of the law. This is a problem I feel in many, many of our ventures, that we rely too much on the law, the letter of the law, the text of the law, the courts. For everything we say there must be a law. Of course there must be a law. I mean, there must be legal enablement, whether it has to be a statute or not. So when you're talking about the culture, this aspect is what allows the policeman. So in somebody, for instance, Henry knows about, somebody who, a household, they think that their jewelry has been stolen. They naturally suspect the servant. And they encourage that matter, Henry, which I did for you, Karupi.
Yes.
So then the entire family, bears down upon the police station to say, beat her. She's the one, they will not talk unless they are beaten. So somewhere elsewhere in society, there is support for this. Second is their ability to get out of it. And there Mihir is right. This judgment has gone into some detail. Okay, there is no CCTV. It's not functioning. It's not my fault. There was no electricity. Let's see who will call us to account. So there is that impurity. It's a combination of these two. And the first will have to be addressed differently. When I actually made the suggestion, somebody laughed at me. The first time I made the suggestion at, one of these human rights, South Asian human rights group meetings, I seldom go for them. Because people are so full of themselves and they're so full of their papers and so full of their solutions and their, disapproval of the nitty-gritty of, the magistracy and the police. And they said, oh, what is the point of this? I said, you have to have language, you'll have to have, plays, you'll have to have somewhere where you're not frontally telling somebody that torture is wrong, but somewhere creating this impression, like ads do, that something is not desirable and something is desirable. You have to work at that level also. I mean, I'm not skilled in that field and I don't know how to, but you have to step outside the legal field and create a kind of, dislike of, disgust of this kind of, this of torture, of custodial torture, and do not make it seem a noble act. A movie show it as a noble act when the honest policeman is thrashing the corrupt politician's rich man's son. What is it but glorification of torture? So at that level also somebody will have to tackle it. We have to tackle it. That's one thing. The second thing is that when we talk about impunity, that nothing is happening, I think to some extent we also have to engage, because we assume, okay, there are these bodies. We've tried this body once, it will not do anything, this will not do anything, the state legal authority won't do anything, the legal... See, there will always be agencies which will not do anything. It does not inhere in any one particular body that the magistracy will never do anything, the police will never do anything, the legal services authority. Sometimes they do, sometimes they don't. The thing is to move through that process and to recognize that we cannot put the burden on the victim to establish a case. It's not like a plaintiff claiming property, but that's what our system is doing. If there is torture, you go, you fight it out, you establish it. Just like if there is just imagine murder cases, if it was left without the state, forget how the state handles it. But broadly, by and large, if there is a case of violence, the police steps in. Just imagine what it would be if the individual person, family, friends had to prosecute it. Torture is exactly that. So there must be a self-generating thing. And I mean, I've had my discussions with Maya Daruwala, who's worked for so long with the police. The magistracy may respond, may not respond, but we have to work with the magistracy either before or after. We have to, because if the magistracy is not responsive, not a million CCTVs is going to make a difference, I can tell you. Because who's to give redress?
Yeah. Mihir, 2010, after several decades, we had the first attempt at a bill to actually criminalize torture. And then we have the recent Law Commission report, 2007, Commission report 273, saying that we should join the international regime. And they also even affixed a bill, suggested a draft, etc., etc. But there's obviously a huge reluctance. It goes across parties, according to me, across all political parties and the political class. I mean, maybe some parties are a bit more amenable than others. How does that get broken? How does one make a breakthrough on that?
As you yourself started out a little while back, that India has not signed the torture and ratified, obviously, the torture convention.
We signed it but not ratified.
Signed it but not ratified. Signed it means that they can't undermine it. Ratifying means they will have to actually work towards implementing it. Now, as far as ratification, see, if you ratify it, it becomes an obligation to have legislations to deal with torture. Okay, and that's one of the reasons why they don't want to ratify it, because they don't want to. For whatever the reason, and see, what happens is that all the ruling parties, whether they pertain to a state or the central government, consider police, and the Home Ministry is considered to be the most important. Right now, from the central government, how Home Ministry is important. So Home Ministry is supposed to be the most important. And one of the reasons why they are supposed to be most important, because the police is in their control. And they do not want to upset that apple cart by having legislations which make the police accountable, because an unaccountable police is very important to the ruling dispensations, no matter which the ruling dispensation is. Okay? And for the present dispensation, even more so. That's important. And therefore, I feel, but we must, and Henry has been working on it for decades, I believe, that there should be a legislation on torture, concerning torture, dealing with torture, because it's not just enough to say, like I said earlier, that torture is anyway a crime. Any kind of physical assault is a crime. Yes, it's a crime, but it's a specific crime. It's a crime based on power. It's a crime based on
control, power,
power, etc. So it requires to be dealt with separately, okay, as an offense. Just as you deal with domestic violence separately, though violence of any kind is an offense. Okay. Similarly, you require to deal with torture, okay, especially custodial torture, okay, of any kind. Separately through a legislation, which makes the police, which makes the authorities accountable. Okay. And I think unless that, and it's very important for civil society, along with trying to push this, because obviously the courts can't direct the legislature to enact a law. So to expect the Supreme Court to do that is out of question. That is our job. That is the job of political parties. That is the job of civil society organizations to push for this legislation concerning torture. Because I think that's a very important. I think that's something which we need to work on towards in a few years. Henry is gone.
No. I think there's a mistake. I was waiting for him to come in on this. I just saw him leave. That's why. I'll probably rejoin. Can you just call him from my phone? So anyway, I wanted him very much on this question because he has worked for many, many years on this. Hopefully he'll rejoin us. You can even WhatsApp him. Finally, I think I just wanted to say that if you wanted to just give a quick, between Nitya and you, you and me, if you wanted to just give a quick sort of sheet for civil society, activists, lawyers, that how we take this campaign to abolish torture, how we get this campaign to make custodial torture accountable. What are the kind of things, given both these judgments that we've been talking about, what are the kind of things that you would advise? How should groups form themselves? How should they activate themselves? How Nitya mentioned law schools and law students. Mihir mentioned civil society. How do we get, if you say 10 points or 15 points, what would you say?
Well, I don't 10 points, 15 points. One is, I would say, active, since we have this judgment, let's start working with the district and state legal, that oversight committee. Ask them repeatedly, work with them, say, okay, every fortnight, let's review the footage and see what's happening in your small units. That's one way. Second is every case of torture that comes to their notice, take it to its fruition. Now, it's not easy. I know we've been fighting cases of torture for a long, long time. Sometimes we do not, but let's not start with the High Court and the Supreme Court, which is what we tend to. We have to conscientize the lower judiciary right up. I mean, this is not because I romanticize the lower judiciary. It's not because they're better. I mean, nobody's better, nobody's worse. You may get a brilliant, excellent, and humane magistrate, and you may get a rotten, somebody completely insensitive person at a higher level. So it is not that one. Two, let us watch. Let's just start this as a pilot project. Let's choose 2-3 courts, High Court, Sessions Court, Magistrate, when they are being brought in. Let's just record what happened. It doesn't have to be case A, case B. It doesn't have to be the case of somebody with whom you politically sympathize. Just sit in a court where people are being produced from custody. Let's just watch it. That's what will tell us how to take this forward. I mean, there is no overarching wisdom that I have about this. It's good if we sign the Torture Convention, we ratify it. It's good if we have a law, but I don't think it makes any difference. I disagree with me. It's a good campaign. But it is not because we don't have a CAT law that torture is happening in this country. Torture is happening precisely because the policemen know that they can get away with it. Somebody else has
So
to
then
take
how
the
do you prosecute them? Because that is something which is missing in even these judgments.
These judgments, you see, when you go to the Supreme Court, you ask,
No, yeah.
I mean, there is such a zigzag of the
Yeah.
Supreme Court directing prosecution. There are times when the Supreme Court has just not even looked at the case.
Yeah.
A woman went to the Supreme Court saying 3 of her sons had been picked up by the police. While the case was being heard, it turned out that one of them had been killed. And the order was, I think this was Harvinder Kaur or something, the old case. They said, well, now that he has been accounted for, they just finished the whole, they disposed of the matter. So prosecuting these cases is not, those cases, torture law is not going to help you prosecute the case. It's already an offense, it's an offense of murder.
Yeah.
So the legal aid must help them establish the case of murder. So ensure that whichever agency, now you can have a victim, have a lawyer. In fact, in my opinion, to an unhealthy extent, victimology has allowed private intervention in a criminal case. I don't approve of it, but it is there. So follow the cases of torture which are there as of now, and then you will know what else you need to do. That I can't lecture to them from where I'm sitting. That is what will tell you where is the lacuna. Is it that the police is not collecting enough evidence? What is the nature of evidence? What are the presumptions that may operate or may not operate? Let's fight for some presumptions. For instance, it's there in the case of custodial rape. It is not there for custodial torture. That if there is bodily injury, which is acquired during custody, there is a presumption against the custodial officer. We don't have that law. We should have it. So when somebody is produced, or you can say that whenever somebody is being produced for medical examination, allow one family member to be present.
Mm-hmm.
So let's have
I think Henry's back. I think Henry is back.
He knows better.
Yeah, Henry, no. Henry, we were talking about the international law, and we were talking about, how important, how will it change if India ratifies CAT? You've been so much part of this campaign. Just help people understand that.
I heard what Nitya said, and I definitely agree with her. It is those small little things that we do with a lot of creativity on the ground, every time in a different way. Document those things which people consider are small things. It is these small things that actually matter. That I think is definitely agreed. But the 1997 signing of CAT and 2020 not ratifying, the first, the second, the third UPR, all of them recommending, 41 countries recommending that UPR, that CAT has to be ratified, etc., not doing, is a consistent act by the state to ensure that they do not ratify CAT. And therefore, I think the campaign has to continue. Those who believe in the international mechanism say it will provide us opportunities through the CAT committee, if CAT was ratified, to be able to do a number of interventions, transferring all that Nitya was saying to the CAT committee and putting pressure. But that is one thing.
So campaign has to continue for that. But for that campaign to sustain, we need documentation of local cases. And that is what is important. And I fully agree. I mean, this is one place where all of us agree on the fact that human rights are better protected at the grassroots through the magistry than through our high courts and the Supreme Court. With great respect to those courts. The magistry, when they are on your side, we saw that in Tuticorin on the 22nd night after the police firing, we saw magistrates going in their without their uniforms and their coats and all into police stations to catch hold of people who were kept in illegal detention. These
and
were
visitors
magistrates.
committee.
Sorry?
You should have
Visitors committee.
Yeah, but then these were magistrates who did it on their own. These were magistrates who ensured that immediately lawyers were appointed from the District Legal Services Authority. So once they learn the art of doing what Nitya said, of enjoying playing with the CRPC and ensuring that they have powers to ensure that the law is respected, they will do it perfectly. And these days of younger magistrates coming with a little larger knowledge, I think they enjoy things and they will do it well.
We've had a fruitful discussion. Mihir, do you have any few words to say on how we take the campaign?
I just want just one quick thing, that I think what has been happening, like the civil society organizations in India, majority, not all, but majority of them, even democratic rights organizations, they get into action once a torture case comes or a custodial death case is reported. There is no real monitoring of police stations, like it happens with some organizations abroad, where you have an actual, you don't wait for a torture case to happen to monitor what is happening. And I think the civil society and democratic rights organizations have to start playing that role, okay, of being, some kind of monitoring bodies, okay, to ensure that these things don't happen and not just get activated once there is a death or once there is a major torture complaint. I
follow the process in peacetime. Don't wait for a conflagration to happen. I think that is very important.
Yeah, that's all. Thanks.
I think that's what Nitya was also been stressing, that follow the process, normal time, peacetime, every single day. Yeah, sorry.
Yeah. They must work to ensure compliance because, the judgment by itself, to some extent, while let us assume that the government will do something, also has decided that outside agencies, non-executive agencies must come in. Elected representatives must come in. So then civil societies organizations must work to ensure compliance with, with all these norms. And we can do it at various levels.
Thank you so much. Thank you so much for this very short notice discussion, and all of you are different ways are sources of a lot of inspiration. Thank you very, very much.
Thank you.
Thank you so much.
Thank you. Bye-bye. Bye-bye.